Hello everyone, my name is Axel. Welcome back to Wisconsin State Statutes. Today we are focusing on the Juvenile Justice Code, Chapter 938. So juvenile justice is a little bit different than adults. For adults, it typically you have a misdemeanor, felony, or a general offense. For juveniles, you have status offense and have delinquency. Juvenile delinquent is someone who's committed a crime that would be also considered a crime for an adult. Typically, it's a criminal offense. Status offenses are other things. We'll get more into that in a minute. This will be a longer video because I will be breaking down the procedures in juvenile court and really getting into finer detail. So first off, what is a status offense? Status offenses are things like running away, ditching school, vandalism, typically like if you're gonna tag a wall, stuff like that. Those will be considered status offenses. They're not considered victimless, and they're considered to be non-violent. Delinquency, if you're found guilty of delinquency, is going to be anything that causes harm or is born out of violence, anything that is a breach of adult criminal code or juvenile criminal code. Now, in the juvenile court system, there's also a thing called a waiver. If a judge finds you guilty of delinquency, they can also give you a waiver, which means not only do you have to go through juvenile court, you also have to get bumped up to adult court, which means you have to go through both court systems, which can be very detrimental. Typically, if you're found guilty of delinquency and you get waivered, you typically get sentenced to a felony in adult court. So, just to start off with things, I'm using the statutes here as sort of a guide. So if I'm looking down, that's what I'm using. Jurisdictions over juveniles. When you're first brought into custody, you're considered to be alleged to be delinquent. Innocent until proven guilty. Someone alleges that you are a delinquent, whether that be an officer or if someone has filed a report. In general, jurisdiction of the court is anyone over the age of 10. And a juvenile is considered to be under the age of 18. Anyone under the age of 10 is part of the criminal code, the children's code, which is a completely separate set of statutes. So we've established minimum age you have to be as 10, maximum age you have to be as 17. If you turn 18, it's an adult. If you commit a crime when you're 17 and you turn 18 while in custody or while the court is in proceedings, you are still able to become a juvenile delinquent. However, you'd be transferred to you'd go to a prison at that point, and you'd be put with adults. Taking a juvenile into custody requires a couple of things. Officers have to make every effort to notify a family, the family or guardian, depending on the case. They have to attempt to do so within the first, I believe it's 12 hours. Look on that in a minute. They have to make contact. If they fail to make contact, they keep the child in custody. There are other rules and laws dictating that. But they have to notify immediately a guardian, legal custodian, Indian custodian, if they're a part of the Indian nation, Native American. In Wisconsin state statutes, it still uses the term Indian. The intake worker must also attempt to notify as well. That's going to be because instead of calling them interrogations or interviews, they're called custodial interviews. They must be at a place of detention. Custodial interviews or custodial interrogations can be done in the field, but there are very strict set parameters for that, and supervisor, etc. So it's not very often done. Big thing to note, 0.195 sub 3, a law enforcement officer or agent of the law conducting a custodial interrogation is not required to inform the subject of the interrogation that the officer or agent is making an audio or visual or audio and visual recording of the interrogation. That's a big one, because if they do that as an adult, you have to. Juvenile, they don't have to. They can record it at any time for any reason. Um, under law, they must make a recording of audio and visual of any custodial interrogations that take place in a place of detention or otherwise. There must be some effort to show that the juvenile was not coerced in any way. They also have to show that the conditions are respectful. So, custodial interviews or custodial interrogations are they have a nice set of laws. Now, there are a bunch of case laws attached to this. I recommend you go and look at those for um, more information on that. Release or delivery from custody. They have to make every effort to release them to a parent, guardian, legal custodian of any type. However, if the juvenile is of 15 years of age or older, they may be released without immediate adult supervision after counseling or a warning the juvenile is appropriate. This is a big one because they don't release adults with bail, but if they're older than 15, they can be released with just a warning or instructions. If they are released, again, they have to notify the parent. Basic rights and duties of an intake worker. Intake worker is someone who, once they're placed in custody, takes control of the situation. It's the person who does all of the background paperwork and follows the juvenile from the moment of intake all the way until discharge. The important duty of an intake worker is that they must inform a parent or juvenile or both that they have been alleged to commit a delinquent act, what the act is, the nature of possible consequences. They have the right to remain silent, which, unlike in adult court, doesn't really mean anything. They have a right to remain silent, and it's not really held against them because of their age. Right to confront and cross-examine those appearing against them, right to counsel, right to present and subpoena witnesses. For the most part, there are a bunch of rights that they have access to. They also can do deferred prosecution. Oftentimes, this is putting a juvenile in like day camps. Different programs designed to help juveniles overcome things such as alcohol or drug dependency or abuse in some cases. I think it's a great system because instead of doing the shock treatment like they do in a lot of states where they put a juvenile in jail for a week and then say, hey, we're going to defer the rest of your time served. Both work to some degree. Those who don't want to be reformed, they're not going to be reformed regardless. Going through, there's fines, fees, different types of things that a judge can do as far as a sentence goes. A lot of the time, if it's a non-violent but a act with a victim, a lot of not only Wisconsin but a lot of states will do letters to the victim, put them in a deferred program such as rehab, counseling, stuff like that, to really make every effort to help a juvenile less at risk and less likely to recommit or generally act out, because most of the time it's kids who just act out. That's why they have such different classifications. For truancy, which is skipping school, fine of $50 for first violation. Number of different things. Habitually, attending programs, workforce development, remaining at home, stuff like that. $500 for repeat offenders. it goes into a lot of detail, and there's so much. I don't think I'm going to be able to cover it all in this video. As far as drug and intoxicating liquors, it starts off with a $50 fine, put into a supervised work program or community service work, and the penalties keep going up from there. If they're underage purchasing it, it goes up again. Provide false proof of age, drug paraphernalia. There's a whole bunch of different stuff, and I highly recommend it. It's a very long read. And if you're having trouble with the legalese or the language that this presents, feel free to drop a comment in any of my videos. I would be more than happy to go over it and kind of summarize it in common terms. I do that a lot at work. So. As far as the rest of this goes, for courts, repeat offenders are subject to physical, psychological, mental, or developmental examination. This is to rule out that it is by parental damage or abuse. Second, it's to rule out psychological or biological or developmental issues. Testing for various diseases and HIV infections. It's another big one. So the last thing I want to talk about is the reasons why they take juvenile into custody. Quite a few. I don't know how to pronounce this word. Rapizas? It's basically a warrant issued for arrest of a juvenile. It's number one. That's the most obvious. Court issued under a judge. A court order showing that the welfare of a juvenile demands that juvenile be immediately removed from his or her present custody. Committed or is committing or has committed an act which violates state or federal criminal law. Warrant from a different state. Court-ordered violation of court-ordered whatever. Violation of conditions, civil law, or ordinance, punishable by forfeiture. Absent from school without acceptable excuse. Or suffering from illness or injury or is in immediate danger, his or her surroundings. Stuff like that. As long as it's truancy, there's also a section in here that talks about the school attendance officer, typically your resource officer. Well, the officer of the law will release him to the officer of the school and basically be under his supervision. They'll also release back to the parents for most first offenses and not do much with it. They'll file a report. And that's from experience as well as case law. Very often, juveniles, officers play around with juvenile law quite a bit. Officer has a lot of say as to whether the juvenile gets put into the court system or they choose a corrective action or deferred prosecution. There are a lot of programs, especially in towns. I know in my town we've got 3. Community service for juveniles, we've got work study for juveniles, as well as delinquency acts, which is sort of programs designed to help juveniles understand what is correct in the eyes of the law and what is not okay in the eyes of the law. So I would check if you're having issues with delinquents in your household or a status offender. Get some help, talk to a counselor, definitely go to school, see what kind of programs are available. Sometimes after school curricular activities is all they need, get rid of some of that extra energy. Sometimes I know there's been a lot of success with therapy as well as extra activities. Definitely talk to a counselor or someone who specializes in delinquency acts and get their take, get your state's laws. Check the link down below to see the Wisconsin state statutes, kind of get an idea. A lot of state statutes are very similar, but definitely check out the ones for your state. There are also local ordinances, like for ours. Our juvenile ordinances are all based on establishing programs to assist juveniles. But yours may be different. So if you have any questions, you can always leave them down in the comments. I try to comment as soon as I can. They go straight to my phone, so usually pretty quick. Um, if you'd like to read more about this, the Wisconsin State Statute 938 of the Juvenile Justice Code, feel free to click the link in the description down below. If you'd like to help support the channel, please click that like button or hit subscribe. I try to do 2 of these a month. Usually towards the middle of the month, I'll post one, and usually towards middle end, I'll post another one. So thank you all for watching, and I will see you next time.